So here is a MSNBC summary. Jamie Raskin is on it. Not a fan of Mr. Raskin because he and all the Democrats, the Dumbocrats, can easily stop this. They can stop this. They can remove Trump from office because he was never constitutionally eligible to hold office. Supreme Court has said that they could take that action to enforce Section 3 of the 14th Amendment at any time. It's come to the point where these people are just effing stupid. Either that or they're afraid of the Trump hellions, the Trump supporters, the unhinged group. And it appears it's the second one. They're afraid of the unhinged group. Now, every time one of these Democrats opens their mouth and doesn't say, we are going to remove him, when they've been sent the realization that Section 3 of the 14th Amendment, and the court has said Section 3 of the 14th Amendment can be used at any time, they have no credibility. But listen to the summary from MSNBC on Trump's first 100 days. That's what's important. There's the title. It's put out by MSNBC. There's the URL up at the top. And there's the date it was published. Or posted, I should say.
On Wednesday of this week, Donald Trump will hit 100 days in office. As he approaches that milestone, a reminder of what he declared and promised to the American people.
I return to the presidency confident and optimistic that we are at the start of a thrilling new era of national success. A tide of change is sweeping the country. Sunlight is pouring over the entire world. And America has the chance to seize this opportunity like never before.
All right, well, fast forward 3 months, and the vibe isn't exactly sunshine radiating across the globe. In fact, the American people are serving Trump and his MAGA administration a sobering reality check. Our new polling shows that 55% disapprove of the way Trump is handling his job as president. A new Washington Post ABC News Ipsos poll also finds his approval ratings have fallen 6 points since February. And when you zero in on Trump's major policies, the results are even more stark. More than half of adults don't like how Trump is handling immigration, managing the federal government, and looking out for the interests of average Americans. And when it comes to the economy, foreign relations, tariffs, and turmoil in the stock market, a staggering 60% do not approve. Now, Trump's 100-day rating is lower than any U.S. president since the 1940s. It's a striking referendum on the dramatic shifts that have come to define the past few months. We've watched Trump upend long-established precedents and sign more than 100 executive orders in an attempt to remake the U.S. government in his image. He's taken his attacks on critics to new extremes, taking aim at universities, law firms, student activists, even the courts. He's gutted federal agencies. He shattered the post-World War II global order and intensely escalated immigration enforcement by deporting immigrants that even include U.S. citizens. It is safe to say that he is testing the limits of presidential power. What could happen in the next 100 days? White House officials say we can expect the administration to focus on trade deals and peace talks. In the words of one Trump official, there are, quote, lots of torpedoes under the water. And executive actions are going to continue like a, quote, snowball running downhill. Trump's unpopular policies will soon face a huge test as well. He is asking GOP lawmakers to deliver on his big, beautiful bill to extend tax cuts, slash an estimated $1.5 trillion in federal spending, and fund his crackdown on immigration. And of course, as Congress returns from recess, Republicans face a major test of unity to pass that spending plan after muscling through a budget framework earlier this month. Also on the table, the question surrounding Trump's demands to some of the country's largest law firms and whether he has violated the law. Democratic Senator Richard Blumenthal and Congressman Jamie Raskin recently wrote to 5 of those law firms which made deals with the president before he could target them in executive orders. They write, quote, "Your agreement makes you complicit in efforts to undermine the rule of law and to turn private attorneys into President Trump's personal law firm." Starting us off this Sunday, one of the authors of that letter, Democratic Congressman Jamie Raskin of Maryland. Congressman, it's great to have you back on the show. Before we get into the specifics of that letter, I want to get your thoughts as we near the 100-day mark of Donald Trump's second term. It is hard to imagine that it's only been about 100 days, given what some say is this unprecedented damage that has been done to our federal government. What are you hearing from your constituents, and what strikes you about this 3-month mark for Trump's second term?
Well, great anguish and upset, both among my constituents in Maryland's beautiful 8th District, but across Maryland, across the country. Donald Trump destroyed $6 to $7 trillion in retirement savings and individual and company wealth. He plunged us into a trade war with the entire world, except for his buddies.
You know, everybody knows that. We're not going to listen to Mr. Raskin because he never answers a question with a solution. The solution is very simple. He's supposed to be a constitutional law professor. Section 3 of the 14th Amendment, if you dissect it, comes out as it was previously described in the beginning of this video. It is a catch-all to impeachment. It uses the conduct of the very person. It's an in personam law. The very person rebelling against the Constitution, to eject them from office. Doesn't matter what office it is. Doesn't matter if you're a Supreme Court Justice, if you're the President of the United States, if you're an attorney. If you've taken an oath, Section 3 of the 14th Amendment can touch you. That's what it comes down to. It does truly come down to justice, domestic tranquility, and to form a more perfect union. These dumbocrats act like they're outraged and there's nothing they can do. Even when you tell them what they can do, they still go on TV talking about there's nothing we can do. As Jessica Denson said, try it, try something. As Chris Hayes said, try it, try something. You know what? Here's the deal, and it's plain and simple. Congress is the only quasi-court in the land. It is not a court of law. It is a political body that has the power of ejection. It can throw any member of government out of government who has taken an oath. They can't see it simply that way. And that's why I say, Mr. Raskin, up yours. And everybody else who gets on there and has a bold-faced lie that they tell the American public that there's nothing they can do. And yet they want to recount and recant everything Trump's doing like they're powerless, when in fact they are the only people in the country who have the power to stop this. All these protests, all the opinion polls, all the issues that the American people think, they have no power. There's nothing they can do to stop Trump short of these people, these Democrats, these dumbocrats in Congress actually taking action to remove Trump. And when they do that, because his transgressions go so far back, they go to January 6, 2021, where he should have never been allowed to take office again. It does what's called a nunc-pro-tunc removal. Him and his entire administration would be flushed from government. Pull your head out your rear, Mr. Raskin, Mr. Durbin, Mr. Schumer, and get rid of this guy. This is the sadpack.com homepage. sad pack is Saving American Democracy PAC. The only site that has the solution to remove Trump, in accordance with the Trump v. Anderson ruling, March 4th, 2024. Behind this will be an analysis of the LAWFARE article on the Trump v. Anderson ruling of March 8th, 2024. Shows how they completely got it wrong. This is what the private legislation looks like that's needed to disqualify Trump. You read the ruling carefully. He is not disqualified until the amnesty vote is taken. People don't seem to get that through their thick heads. And this is what it looks like. It's a resolution, same as a censure resolution. Describes at the Supreme Court what they said, describes what the Supreme Court defined and affirmed, describes what the Supreme Court specifically made clear, that Congress has exclusive jurisdiction by the final sentence of Section 3, describes that the Supreme Court made clear that Congress exercised the amnesty power post-election, and then it goes into what Trump has done. And this goes on for 9 pages or so. You're welcome to go download it. There's the URL up at the top. And this is how Section 3 of the 14th Amendment is enforced. This is the legislation, specifically the appropriate legislation that the Supreme Court speaks of. It's pretty sad that either the lawmakers don't understand this, including the lawyers that are in Congress, or they're all just too scared of Trump supporters, the unhinged ones that will come after them, that they'll be looking over their shoulder all the time. And so they're just going to collect their $175,000 a year and let whatever happens to the country happen to the country. In the first place, no one should be in Congress collecting that kind of salary who's not a lawyer. That's what a junior associate is paid after going through law school, coming out, passing the bar, and then getting a job with a law firm. A secretary, a waitress. You know, 2 waitresses we have in Congress, AOC and Boebert. I'm sorry, you know, you can't be a lawmaker if you don't understand the law. You can get out there and you can run your mouth about concepts politically. That doesn't solve the problem. This solves the problem. This describes what Trump has done, describes the congressional laws violated, describes his conduct, starts out by stating before he's even gotten to the 100th day, everybody is saying he's a Herbert Hoover. Even Mitch McConnell is saying he's a Herbert Hoover. He's talking about the Smoot-Hawley disaster. And this is what you do. You immortalize this in the record, and then you vote. You vote on whether you're going to excuse this whole mess and then let him be the president, or if he doesn't make it to the excuse, he's then, and only then, disqualified. So let's move on to the analysis of the LAWFARE article up next. The previous video focused on why Section 3 of the 14th Amendment is a catch-all and a drop-in replacement for impeachment. Aside from the fact that the spread of time in which the two entered American politics, it should be obvious that it became clear to the government officials that impeachment was too cumbersome and would never work, especially in the case of insurrective action. Section 3 of the 14th Amendment picks up where impeachment leaves off, going backwards and forward. It allows, as the Supreme Court has determined, by special legislation, which is nothing more than a simple resolution identifying the violation of Section 3 of the 14th Amendment, and then the required 2/3 vote to actualize it. This is a Google search for Section 3 of the 14th Amendment analysis. There's the first one from congress.gov, and there's a few others. Then there's the insurrection bar to office, which is a PDF. I believe it's LM 1059 something or another. Let's see what it is. Yeah, LSB 10569, and it goes deep into how to use it in terms of quo warranto. It doesn't deal with too much of anything else, but you should read it. Then there's NBC News, irrelevant. Democracy Docket, irrelevant. New York Times, irrelevant. And LAWFARE, which is relevant because it's one of the few true legal analysis of Section 3 of the 14th Amendment from the Trump v. Anderson ruling. And here it is on the LAWFARE site. The title, What the Supreme Court Got Wrong in the Trump Section 3 case. Obviously, this is a negative review, and that's the problem. It's March 4th, 2024. It was posted when the ruling came out March 4th, 2024, from the Supreme Court. They say the court botched illegal reasoning and heavily on dubious policy. Well, that's wrong. That's just completely wrong, and we're going to go through it paragraph by paragraph. Let's start with the overview. Section 3 of the 14th Amendment, according to the Supreme Court, is something that states can do against state candidates, but states cannot do against a federal candidate. And the reason they say is because Congress has jurisdiction over that matter. Now, unfortunately, they're not clear. This LAWFARE article, as you see right there, says Section 3 is not self-executing. Well, that's not what they said. They said it is self-executing, but it's not self-actualizing. Meaning, on page 10, bottom of page 10, top of page 11, they identify what Section 3 does. And it says, any person after having taken a qualifying oath and then engaging in insurrection or rebellion is barred from office, nothing more. Now, this is the other problem with America. We got stuck on insurrection. We got stuck on trying to prove that Mr. Trump was involved in insurrection. He was not. He was involved in a rebellion. He was involved in personal rebellion against Article 2, Section 1, Clause 1. Nobody says that. But in that, in itself, the Supreme Court of Colorado and the lower court got this all wrong. Well, in addition to Crew bringing the case wrong, because it was supposed to be a mandamus action, not a full-blown trial. And this paragraph right here says, the court ruled that only Congress acting through legislation has the power to determine who is disqualified under what procedures. That is 100% correct. It follows from the very language of Section 3 of the 14th Amendment itself, the final sentence. There's only two sentences. The final sentence is a jurisdictional sentence which says, Congress has the power to relieve the disability by a 2/3 vote. How is that done? Well, it's done through legislation. Legislation is any act of Congress that accomplishes a result. In this case, it would be private in personam legislation. In other words, you simply identify what the person did under Section 3 of the 14th Amendment, identify how it is a rebellion to the Constitution of the United States, congressional laws, oath of office, or even in the most simplest terms, violates justice, domestic tranquility, and to form a more perfect union. Then you identify the actual conduct which violates those axioms, whichever one you identify. They go on here, the author goes on here and says, this outcome was predictable based on the oral argument which focused on this issue. Well, it's very true, because Justice Roberts asked Jason Murray, how does it work? How does it work? Jason Murray said, well, you're supposed to tell us how it works. And they did. Then they conclude, says, but the court nevertheless got the issue badly wrong. Disagree. They got the issue completely correct. But if you're seeing that they got it wrong, then you're never going to understand how it works. The next paragraph says, sometimes unanimity is no guarantee of correctness. Well, the unanimity is a guarantee of correctness in this case, because there is no real unanimity. The thing that they're saying is not unanimous was the three females on the court, Sotomayor, Ketanji Brown Jackson, and Elena Kagan, who further down in this article, their quote can be found. And then they go on to identify what Section 3 states. It says, engaged in insurrection or rebellion against the same. Against the same is the Constitution of the United States. Now that's missing because the ... is where it says against the Constitution of the United States. What this means is, in simplicity, is that insurrection has a very weak definition. It is found in 18 U.S.C. 2383. It was mentioned in the Trump v. Anderson ruling, and it also defines rebellion. Insurrection or rebellion is a violation against congressional laws. Not state laws, but congressional laws. So that means much of anything that Trump is doing today, almost all of it, is a violation of Section 3 of the 14th Amendment. Now, here's the problem. Most congressional members, too many congressional members, are not attorneys. And those that are don't know how to think in constitutional terms. In the Constitution, it sets out a concept that you must build a legal framework around. And here, in this Trump v. Anderson ruling, which this article is referring to, tells you how to build that legal construct. It also gives examples of how that legal construct has been previously used. And at page 8, referring to footnote 2, it gives an example of how it has been used in the past. So you can't say that the court got anything wrong. They didn't. They said states cannot do this. They can do this for a state candidate in a state election, but not for a federal candidate in a federal election. So they're not saying the procedure was wrong. They're saying that you can't do it for a federal office. And they're correct, because by the very language of Section 3 of the 14th Amendment, the final sentence, and there's only 2 sentences to Section 3. The final sentence says, but Congress may by a vote of 2/3 majority in both houses relieve such disability. Now that implies to most people that it's self-executing. No. The Supreme Court is saying it's self-executing. This article says they're saying it is not, but they are saying that it is actually. They're saying that he's constitutionally ineligible, but that the actualization must be done by the 2/3 vote in both houses, or one house if it fails. If it fails in one house, then it'll never make it in both houses, so that disability will not be relieved. Then that person, that party, is disqualified under whatever axiom of the violation of Section 3 of the 14th Amendment applies. It's not confusing at all. It's confusing if you want to see it as confusing. It's confusing if you think you're already defeated, but you're not. Then they go on to say, by focusing exclusively on the self-execution issue, the court left for another day all the other arguments at stake in the Trump case, such as whether the Jan 6, 2021 attack on the Capitol qualifies as an insurrection. Well, the Supreme Court's not there to determine whether it's an insurrection. And even if it was, it would have to be a federal court determining it was an insurrection. It would have to have been brought under 18 U.S.C. 2383. It would have had to have been a criminal proceeding somehow brought, because Section 3 of the 14th Amendment is a civil proceeding. Now, it can be brought under D.C. Code 163501 in the D.C. Federal District Court after the DOJ refuses the case, and then by private individuals. But to get at the point of keeping a person off the ballot, well, Section 3 doesn't speak to that. Section 3 speaks to barring them from office. So the best you could do is determine somehow that they're barred from office. Well, proving an insurrection, even Judge Ludwig said, is a pretty tall order. It's hard to do. You can't just say, oh, you sent people to the Capitol and they're rioting, so that's an insurrection. It is not. It's a riot. However, the rebellion was the effort to violate Article 2, Section 1, Clause 1, which is attempt to stay in power using the fake elector scheme, which failed. Nobody concentrated on that. No one focused on that. And that is where the legal power actually lied. Well, they go and say whether Trump engaged in it, whether his actions were protected by the First Amendment, and whether Trump received adequate due process, and whether the president is an officer of the United States covered by Section 3. The justices may hope they can avoid ever having to decide these questions. Well, they never had to decide those questions. Because the question was Section 3 violated? It's not a question of whether he's an officer. He is an officer. That's not a question. The question is, was Section 3 of the 14th Amendment violated? Now, if this had happened before Trump ever became president, and he had not taken an oath of any kind, he's not an attorney, he's never in the military, he's not a naturalized citizen, and because of that, he could have never run for president anyway, there would have been no oath, and then Section 3 would not have applied at all. So this is the first place that this article from Lawfare falls down. He goes on, in my view, Trump deserved to lose. Okay, that has nothing to do with it. All it has to do with, he already lost. All it has to do with is identifying whether he violated Article 2, Section 1, Clause 1 of the Constitution. Was he in rebellion to Article 2, Section 1, Clause 1 of the Constitution in his attempt to stay in power by using a fake elector scheme, attempting to use a fake elector scheme, and disrupting the count? And does that constitute public knowledge of the violation of Section 3 of the 14th Amendment? Of course it does. This article begins to wander, and it's off base already. At the close of this, they say the court's venture into policy was also indefensibly one-sided, failing to consider the practical dangers of effectively neutering Section 3 with respect to candidates for federal office and holders of such positions. Well, where this Lawfare article goes wrong is that it is not a court's duty to determine this, and certainly not a state court's duty. There are three manners of constitutional ineligibility that are hard and fast in the Constitution. That is age, natural born status, and whatever it is, the residency requirement, 10 or 14 years, whatever it is. There is one provisional constitutional ineligibility, and that's what we're talking about here. Section 3 of the 14th Amendment, which this article says is not self-executing, and that Congress must determine by appropriate legislation. That is 100% correct. He murdered Article 2, Section 1, Clause 1. But until Congress says he murdered Article 2, Section 1, Clause 1, he gets away with the murder. It's just that simple. Somebody, one person only, it takes to file the appropriate resolution, which takes the form of a censorship resolution identifying how he murdered Article 2, Section 1, Clause 1, attempting to stay in power. That forces a vote, the 2/3 vote, in one or both houses. If it fails in one, it fails in both. That is what the Supreme Court is speaking about as the legislation needed to actualize the disqualification. So he's not disqualified right now. He is constitutionally ineligible, provisionally constitutionally ineligible, because we know he's done the conduct. He's done acts of conduct in violation of Section 3. This is what people don't understand. This article, which is probably the best one on the internet so far, that attempts to analyze the Trump v. Anderson ruling, is how they get it all wrong. It's not how the court got the law wrong, which is next section is about. He says under the court's approach, only Congress has the power to determine which people are to be disqualified under what procedures. That's correct. That's correct. The majority claims that Congress's, the majority, meaning the majority of the justices, claims that the court's power to enact appropriate legislation enforcing Section 3 is 14th Amendment. They put appropriate in quotes. Appropriate in this case is a resolution taking the form of a censorship resolution, identifying Section 3 as the basis. There could be other legislation that could be brought also. In this case, a resolution that calls for the amnesty vote, the 2/3 amnesty vote, to excuse the conduct is all that's needed. It produces the final result. Now, there is a possibility that Congress could structure some kind of permanent legislation to allow states to do the same thing. It's not needed. There's already legislation in the D.C. District Federal Court, which is D.C. Code 603501. It's been there for a long time. It uses the writ of quo warranto as a basis to make the argument of why the person should never hold office. So again, this article is wrong there. Then they say there are several flaws to the court's analysis. Flaws to the court's analysis. Well, no, they're wrong. Let's go with the first one. The most basic is there is no good reason to believe Section 5 is the exclusive mode of enforcing Section 3. No, it's not. No one ever said that. It just says Section 5 is what gives Congress the power to enforce 14th Amendment in general. And then they go on, as the Colorado Supreme Court emphasized in its ruling, let's be blunt, a ruling they had no jurisdiction to make. Section 5 empowers Congress to enforce not just Section 3, but every other part of the 14th Amendment. Okay, so what? Irrelevant. Including its protections against racial and ethnic, blah, blah. So what? There are other provisions considered to be self-executing. That doesn't matter. This provision is self-executing. It's just not self-actualizing. Because in order for it to be self-actualizing, the final sentence would have to say, this violation is relieved. It says the violation can be relieved. This ability can be relieved. It would need to be reworded to say this bar to office, automatic bar to office, is relieved only upon an amnesty vote. Something to that effect. That is in essence what it says. But people are so busy trying to read it the way they want to see it, they don't see what it actually says. There is nothing wrong with the Trump v. Anderson ruling at all. Because as a matter of fact, they identify and declare certain things that were foggy before. They declare that Section 3 of the 14th Amendment is self-executing. It says, bottom of page 10, top of page 11 of the PDF version, it identifies what Section 3 is. It says, if after taking qualifying oath, you engage in insurrection or rebellion, you are barred from office, and nothing more. Nothing more meaning there's nothing else need be done. That is the self-executing nature. Then as the Supreme Court ruling notes, they say, following its landmark precedent of City of Bourne versus Flores, they go on about the remedial nature and, la. Well, that's self-evident. It really is. Except that Congress becomes the political adjudicative body, and that it must enforce Section 3. It doesn't enforce itself. It's not like turning 35 and now you can run for president, or being naturally born here in America and you can run for president. This is a provisional constitutional ineligibility. And until Congress recognizes the provisional constitutional ineligibility, it's as though you murdered Article 2, Section 1, Clause 1, and you got away with it. That's where Trump is today. He murdered that section and got away with it. However, in the ruling, Supreme Court also says that this can be enforced by Congress at any time. Then they go on here to talk about, as the three liberal justices, Jackson, Kagan, and Sotomayor, note in their concurrent opinion, it's hard to understand why the Constitution would require congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing, declining to pass implementing legislation. I don't know who or what or where they came up with that crap, because that isn't how it works. Section 3, by its own wording, says it takes a 2/3 majority vote. Their legislation doesn't have to take the form of a simple majority. In this case, congressional supermajority is required to remove or place a disqualification. Meaning, if you fail the supermajority, the disqualification is activated. If you reach the supermajority, the disqualification is nullified. There is amnesty then. I don't know who came up with that language, and sadly, it's the three females, and they're wrong. They're just wrong. It doesn't say that. Nowhere does a simple majority come into this. They must be thinking about legislation that goes through both houses and then lands on the president's desk. That's not the legislation that's referred to here. And while we're here, let's just talk quickly about the ECRA of 2022, which requires a one-fifth majority of both houses to lodge an objection to the counting of electoral votes. And it doesn't say the objection must be under Section 3. But under Section 3, if it's raised under Section 3, then in theory, by the Constitution itself, only one member need file that. So there's a constitutional incongruity with the ECRA of 2022. We never got there because nobody objected on January 5th, 2025. They go on with their little thing here about U.S. term limits with their little green sidebar. Nothing in the Constitution delegates to the states any power to enforce Section 3 against federal office holders and candidates. That's true. And here's the problem. It's a provisional constitutional ineligibility. It is not a hard constitutional ineligibility, which they talk about below here, where in previous ruling by Neil Gorsuch, he upheld that a natural-born citizen could be kept off the ballot. Well, that's a hard constitutional ineligibility written into the Constitution. It is not a provisional constitutional ineligibility. So, again, just words wasted because the argument is irrelevant. U.S. term limits in Thornton, precedent relied on the court holds that states cannot impose term limits on members of Congress because they lack the power to impose additional qualifications. But there are no additional qualifications being involved here. But that is not what Colorado did here. No, that is exactly what Colorado did here. They are taking a provisional constitutional ineligibility and adjudicating it to apply to theoretically keep Mr. Trump off the ballot. I'm sorry. When you look at it backwards, it comes out to bite you in the butt. The next sentence goes on, and it tries to argue that U.S. term limits doesn't apply. No, it does apply, because it says the former block states from enforcing an existing qualification for office mandated by the Constitution, not just imposing new ones. Well, again, it's a provisional constitutional ineligibility until Congress recognizes it, and that is what the Supreme Court is trying to say in the Trump v. Anderson ruling. It's up to Congress to recognize this at any time, take the amnesty vote, and then he's off the ballot or will never be able to hold office if he stays on the ballot. So you'd be voting for a dead horse candidate. Congress didn't do that. Congress slept at the wheel, and we have the crash into the tree. They try to say the distinction between state and federal offices is nowhere to be found in the text and meaning of Section 3. I would say it does. And the reason it does is because it's a federal constitutional provision. It is under the Supremacy Clause that says if you are found guilty of this Section 3 violation, you cannot hold office, state nor federal. But it doesn't say the other way around. It doesn't say a state may determine this. It implies the opposite. It implies that only Congress may relieve the disability caused by Section 3. Well, unfortunately, what it doesn't say is that somewhere, somehow, the amnesty vote must be taken anyway before the disqualification is firm. But that's what the final sentence of Section 3 says. They may relieve the disability by a 2/3 vote, meaning disability is there, but it is not actualized. And until it is finalized by the amnesty vote and it fails, then they are disqualified. When you see things backwards, you write bass-ackwards articles like this. They talk about the Griffin case in 1869. Irrelevant again. It has nothing to do with Section 3 of the 14th Amendment as to a federal candidate. Now, it also has nothing to do with Section 3 of the 14th Amendment as to removing a party from office. This had to do with something not even relevant to this particular instance of a federal candidate for a federal office. You're welcome to read that. This attempts to say the council's argument that Section 3 executes itself, and indeed, and needs no legislation on the part of Congress to give it effect, is true. However, it does need the final appeal in a political sense, is it does require the 2/3 majority vote to fail in one or both houses before the disqualification is actualized. Until that time, until legislation is brought by filing a resolution outlining the violation of Section 3 of the 14th Amendment and what it is for Congress to vote on, it doesn't exist. They murdered Article 2, Section 1, Clause 1, and got away with it. We all know it. We all saw it. We all know that's what happened. But until actually being charged in Congress, it doesn't matter. So that's the point where it has to be, the legislation has to be brought as private legislation to cause the effect of the amnesty vote. Either fail or pass. When you fail, you're disqualified. If it passes, then you're not guilty. It is that simple. And I don't understand why everybody wants to go on and argue all this other stuff. So we're getting near, I think, the end of this article. And it talks about other people, some critics. Tries to say they're overblown. If state officials or state courts reach unsound, contradictory legal conclusions about the meaning of Section 3, well, the problem is there is no interpretation of Section 3. Section 3 is a rebellion. You know, forget insurrection. The insurrection is what screwed this whole thing up, because that's where you're all over the place trying to prove insurrection. But rebellion is what really went on here. If you use rebellion, it takes the form of mandamus. Article 2, Section 1, Clause 1 was violated January 6, 2021 by attempts to stay in power, inciting a riot, which everybody calls an insurrection, inciting a riot, and having a fake elector scheme to attempt to put in place to stay in power past 4 years without being legitimately reelected. That is the violation of Section 3 of the 14th Amendment. No one went that route. So everybody's trying to explain it through insurrection. Never going to happen, because there was no insurrection. So they go on and try and besmirch. A large part of the docket routinely consists of cases where state Supreme Courts and federal appellate courts have reached divergent opinions, interpretations of one another, blah, blah, blah. Has nothing to do with it. What the Supreme Court was saying was that you must identify an insurrection in a federal court. A state court cannot determine an insurrection for a federal candidate. It must be done in a federal court. And as I said, DC Code 163501 leaves that door open. However, you're stupid to go that route. The simpler route, the more correct route, was a rebellion route. No one ever went that way. And that's where we are today. He murdered Article 2, Section 1, Clause 1, and got away with it because everybody went for the parking ticket of insurrection when the murder occurred in rebellion. They go on about all this other crap. Birthright claims. You don't understand. It's simple. There are 3 hard and fast constitutional ineligibility disqualifications: age, natural born status, and 14-year requirement. That it says that here. But Trump was none of those. Trump was the provisional situation of Section 3 of the 14th Amendment, and that does not apply. It applies only when Congress says it applies. And they go on and try and argue about, divergent conclusions. The bottom line is, Crew, considered Citizens for Responsibility and Ethics in Washington, Crew, brought this case wrong. It was a mandamus case under Colorado law. They turned it into a full-blown trial. A full-blown trial on insurrection. If they had turned it into a full-blown trial on rebellion, the outcome may have been different if they had simply used federal standard of rebellion. For instance, the D.C. Circuit Appellate Court declared Trump violated Article 2, Section 1, Clause 1. I'm not sure if that was done in time for this Colorado ruling, but it was done in time for the appeal. No one ever mentioned it. So this is an article that went down the wrong road because they wanted to go down the wrong road and trying to argue how the Supreme Court got it wrong when the Supreme Court got it completely correct. It's just that nobody is seeing what they actually said. They talk about the dangers especially acute in a case where the insurrectionist, stop with the insurrectionist, is a candidate for the most powerful office in the land, some degree of patchwork divergence. None of that is relevant. None of that is relevant. What's relevant is he violated Article 2, Section 1, Clause 1, and no one ever charged him with that, formally or informally, or even mentioned it in argument. This goes on, and now it lands in the end nowhere. The impact of the court's decision. Well, Trump can assume the presidency if he wins the 2024 election. No, it didn't say that. It said that Congress may at any time enforce by appropriate legislation Section 3 of the 14th Amendment. Congress didn't do that. Congress, they got the boo from the Supreme Court, and they did not read the order. It says, in theory, and you have to remember this is March 8th, 4 days after the ruling in 2024, Congress could enact new enforcement legislation between now and January 20th. No, not needed. All that's needed is private resolution enforcing Section 3 of the 14th Amendment, taking the form of a censure motion identifying how Section 3 of the 14th Amendment is violated. That is legislation. It becomes legislation as soon as it's filed with the clerk's office in whichever house it's filed in. And then Congress, that house, is forced to vote on it. If the vote fails, it's over because it will never pass in the next house. If the vote passes and the disability is relieved, then it must go to the next house, whether it's down from the Senate or up to the Senate. And if it fails there, it's over because it must pass in both houses. That's legislation. These words here are the words of an author who's got myopia. He's seeing it completely backwards and is wrong. Just flat out friggin' wrong. This is 4 days after the decision comes out. Everybody's mad. Everybody's got fire in their eyes. And they're all trying to say how the Supreme Court got it wrong. In protest. Like that's going to do anything? No. Look at the order as if, how can this be correct? And if you do, it's throughout the whole order. It starts out by saying, the respondents claim that Mr. Trump is constitutionally ineligible. They never say he is not. Then it goes on through a bunch of facts of the case. Then it goes on, it says, we conclude that a state may do this for state candidates, but may not do it for federal candidate. And then you need to stop there and say, how is that? Why is that? And then read on. And the order tells you. And then it gives you, it says Congress has the power of this. Is returned to a federal candidate. Now, in a state constitution would have that power by adopting the federal constitution. Well, the state does not have the power to overlay its state constitution onto the federal constitution. It is completely subservient to the federal constitution. That's what people seem to have gotten all wrong. The court does suggest that state governments can disqualify insurrectionists from holding office. See, stuck on insurrectionists. That's not the issue. It's rebellion. It's rebellionists. It's rebellion that is what is really should have been the legal standard here. And when you go to insurrection, you go to an issue that has to be judicially proven. You're off the rails. Not going to happen. And then they mentioned 2383, federal statute, which the court's opinion describes as enforcement under legislation under Section 5. Well, of course, some insurrectionist federal office holders might be convicted. No. You don't need to be convicted. All you need is use the standard of the congressional law of 18 U.S.C. 2383 as a definition. The federal insurrection statute, which the court's opinion describes as enforcement legislation under Section 5. Of course it does. But Congress is not a court. Congress is a political body, and it can use the definition under 18 U.S.C. 2383. And it says insurrection or rebellion and congressional laws. That's a violation of Section 3 of the 14th Amendment. And then they go, such convictions may be difficult. Then the court has gone on to say, nothing more. You don't need a conviction. This is where people are stuck. They're stuck with this court. Courts will never have the power to affect the political outcome. Only the Constitution has the power to affect that political outcome. It's right there in Section 3. If you take an oath and you fail to follow that oath, and you're in open rebellion to the Constitution in either insurrection or rebellion, which includes violation of congressional laws, then you're barred from office and nothing more. You don't need anything else to be done. In any event, there's no good reason to believe that a criminal conviction is a prerequisite to Section 3. Of course it's not. No one ever said that. And then he talks about his amicus brief. You can go find this, look it up, and all these links will work there. They're not going to work here. But my guess is whoever wrote this is wrong. They're wrong for a very number of reasons. It says Section 3 is intended to protect liberal democracy against allowing insurrectionists to return to power. Okay, you're stuck on the insurrectionist. First of all, Donald Trump is not an adjudicated insurrectionist because the court had no jurisdiction to adjudicate him an insurrectionist. Even under the Colorado statute in which this was brought, it does not require a trial. It does not allow for a trial. It allows for a simple hearing, and they went way beyond that into a trial. they talk about protecting democracy and liberal values against catastrophic bad choice by voters. Don't blame the voters. You need to blame Congress, because it's Congress who doesn't know how to do their job. Now, that's the end of this. And up next, there's the link up at the top. You can also find it by putting in the title. And you can find it through the search page that I just showed at the beginning. But after this is Chuck Todd talking about corruption. The truth is, the persons to blame here are the Democrats in Congress. They didn't object. They didn't know how to object. Or maybe they did and they were just afraid to object. And I think it's probably the latter. They're afraid of Trump's unhinged supporters who would be waiting in the weeds to try and kill them, assassinate them, run them down, shoot them. You know, we've seen that over and over again. The guy who set the governor's mansion on fire in Pennsylvania to try and kill Josh Shapiro. And the list goes on and on and on. But that doesn't change the fact that this article, which is probably the only one that attempts to do an analysis of the Trump v. Anderson ruling, and nothing has been done since, over a year. This was March 8th, 2024. Over a year, and you won't find anything else analyzing the Trump v. Anderson ruling. These are assumptions made from what they think they read in the ruling, which is plain out wrong. And again, here is the title. Brookings Institution. What the Supreme Court got wrong in the Trump Section 3 case. Now let's move on to Chuck Todd and his guest, Mr. Ghibley, who has done several documentaries on how we got into this mess with Citizens United. Now, here, the scope and sweep of Section 3 is broader than what this article is saying, and even than what the law review article of that title is saying. Section 3 is a drop-in replacement for impeachment. It is also a protection to the Constitution against bad thought and violations of concepts in the Constitution. For instance, the First Amendment, the argument about religion, the issue with what many people believe makes America a Christian nation. All of that is a Section 3 of the 14th Amendment violation because it is in rebellion to the First Amendment. Until the Democrats in Congress learn to prosecute under Section 3 of the 14th Amendment and bring the appropriate legislation against these parties and persons who have taken an oath of any kind, this will continue. This is Chuck Todd speaking with a documentary Alex Gibney creator. He goes into deep detail on how the American legal system is so screwed up by, in essence, what at the root is the Citizens United case, that there's not much way out. There is the title, and here is the date, April 25th, that it was posted. There's a URL up at the top. You can stop at the ampersand t equals 1200 because that's where it jumps to. Because Chuck Todd spends the first 20 minutes running his mouth. He likes to run his mouth, and I'm sorry, not a fan. Not a fan. Chuck Todd is just another media type who wants to do the dialogue forever. And he really doesn't have anything meaningful to say other than bringing on the guest who really has it all to say. I encourage you to go watch this from the beginning if you want. This jumps to 1200 seconds, which is 20 minutes into the video, which is where he actually asks the first question of Alex Gibney.
We're all cynical about it. Oh, sure, there's money in politics, we get it. But we don't really.
There's that great set line from an old
See,
senator.
he runs his mouth. He's got to run his mouth.
There, and eventually you get
Shut
real
the
money.
F up.
Right.
You know, it was bad, and it feels that way sometimes in campaign finance. Oh, he's got a billionaire super PAC. He's got a billionaire super PAC, and we all just sort of, you know, roll our eyes.
This is just meaningless.
Yeah, but I don't think we really get it in terms of where it's got to at this point and exactly how it works. And so that's why, and I had done this, you know, I'd been on this beat for a while. Some years ago, I did a film called Casino Jack in the United States of Money. And it was about disgraced lobbyist Jack Abramoff, who I give a sort of tip of the hat to in Ohio Confidential. But that one was not, that did not break through. Because people are like, lobbyists, money, what people need to understand is that we've created a system of legalized bribery, and I think most people don't really understand, most people get emotionally the idea of a bribe, and they're deeply offended by it. So if we replace campaign finance with legalized bribery, now we're talking about true crime, and we're talking about the real problem, which is a few people getting advantage over the rest of us, and they're the ones who are insisting that the policies work for them, not us.
So I want to dig into Ohio Confidential.
Yeah.
I'll be honest. Look, as a
Okay, and you know, there goes Chuck. He's got to run his mouth. These YouTube content creators don't understand. Nobody needs to see your face. Nobody needs to hear you run your mouth. You have nothing to offer. Shut the F up and let the guest, who is the expert, speak. Now this goes on, as you can see, for an hour and 15 minutes. The last, I think, 15 minutes or so was Chuck Todd again running his mouth. However, this starts at about 20 minutes in, and I encourage you to go watch this and listen to what Alex Gibney has to say, because he's describing how Section 3 of the 14th Amendment could also be used to undo this whole Citizens United mess, because nothing about it promotes justice, domestic tranquility, nor to form a more perfect union. It does the opposite. And that's where the Supreme Court justices have screwed the country. That ruling could be undone. Certain justices could be removed from the Supreme Court by Section 3 of the 14th Amendment. They know that they're just as susceptible to Section 3 of the 14th Amendment as is anyone who takes an oath of office in government. And so therefore they were not trying to tell anybody exactly how to use it, because they'd be next. Now, in the previous clip about the LAWFARE, the three female justices, Sotomayor, Kagan, and Jackson, you know, asked the dumbest question in the world. You know, why did you have to go there with something that a simple majority can do? Well, you know, that's where they're not thinking. A simple majority does not do it. It takes 2/3 majority, and actually takes a minority to launch it. But in order for Section 3 of the 14th Amendment to work in any legislation, you cannot change the basis of the legislation needed, because the Constitution requires 2/3 majority vote, does not allow a simple minority to do that. The legislation they think that's being created is legislation that goes through both houses, is crafted. And you can't craft something off of Section 3 of the 14th Amendment. It stands on its own. And that's what they did with the ECRA of 2022. They tried to recraft something that actually gets in the way of Section 3 of the 14th Amendment. That makes it unconstitutional. But until somebody takes that to court and challenges it, which most any court would say, yes, this fails, because you can't hamstring Section 3 of the 14th Amendment requiring a 1/5 majority vote in both houses before you listen to the Constitution. You can't do that. Until that goes into court and someone challenges it, it's going to stand. And it won't be used until every 4 years when it's time to re-elect the president and count the electoral votes. At which point, they would have to stand up in Congress and say, you can't require us to have a 1/5 majority vote in both houses before this objection will be considered valid. Now, I don't know what to say. These people think that YouTube is their TV channel and they're supposed to sit up there and be, Mr. Broadcaster Commentator. They are not. Go listen to Alex Gibney. He has a solution to what's wrong, and this is a solution on how to fix it. Section 3 of the 14th Amendment could be launched by any member of Congress against whomever they want to target that has taken an oath to support and defend the Constitution. You cannot legalize bribery if it is a constitutional law or a congressional law against it. If you can't say, oh, this court order makes bribery legal. But Gibney is saying that, and he's correct. And until somebody in Congress has the brains to say, you can't legalize murder, you can't legalize bribery, you can't legalize, immunity to congressional law, then it'll stand. So the immunity decision by the Supreme Court is also a violation of the Constitution. But somebody in Congress has to bring a Section 3 of the 14th Amendment resolution against whatever justices voted for that and identify exactly how it violates a congressional law. When they do that, that justice is gone. They'll be thrown out of the Supreme Court. It's just that simple. They're all running around talking about we're not the majority. Just like Sotomayor, Kagan, and Jackson talking about how can a simple minority, override the 2/3 majority required. Well, they can't. You just, don't think these people aren't all perfect. They got it ass backwards sometimes too. And here is an example of one such instance. Go watch Gibney, what he has to say. Look up his documentaries, and you'll see that the answer is as simple as a resolution that's already been shown. Just recraft it into identifying what is a Section 3 of the 14th Amendment violation. All of these Section 3 of the 14th Amendment violation adjudications, prosecutions, are in personam. They are against a specific person. And so maybe you need to bring 5 of them against all the justices that crafted this ridiculous order. Citizens United, even the abortion case, everything that does not promote justice, domestic tranquility, and to form a more perfect union is unconstitutional. And oh boy, that's broad. Really? That's really, really broad. Really? You betcha it is. And that's what they don't want you to know. That's what they don't want you to know. And it's just that simple. You don't need to see anybody's face on YouTube. You just need to hear the facts. Now, let's move on to a quick thing with, I believe, George Conway and Sarah Longwell, where she just says one thing, that they're all, well, anyway, listen to what she has to say. Before we get to George Conway, here's a couple of more videos that you need to consider. Again, there's a URL up at the top there. This is about the issue with devaluing the dollar. There's the title below. It's just how old it is, but it's relevant yet today. And we'll just...
The US dollar has been the dominant currency in the global economy for nearly a century, and most of the institutions in the current financial system in the world today were created back in the 1940s at a time when much of the world was still colonized by the Western imperial powers. And they designed these financial institutions at the Bretton Woods Conference in 1944 in a way that guaranteed that the Western economies would have significant influence over the global financial system, and in particular, the United States was given veto power in international financial institutions, and the US dollar was made the global reserve currency. This has given the US and also some other Western countries very significant power in the global financial system. And Washington has turned the dollar into a geopolitical weapon. 1/3 of all countries on earth are under US sanctions, including 60% of poor countries, which are suffering under US unilateral sanctions, which violate international law. And in addition to imposing...
You get the point. Go watch the whole thing. It's an hour and 30 minutes long. And at the very core, when we're talking about tariffs, we're talking about trying to maintain a standard of living that simply isn't possible anymore globally, because technology now exists where lesser skilled labor can produce high quality products. You pay a robot once, and at that point, the skilled labor that's required is not a machinist. It's not even a welder anymore. It's just an assembler. And assemblers are a dime a dozen. In Mexico, they're $2.50 an hour versus $25 an hour in America. So let's just hop to two other quick videos before we get to George Conway that illustrate the hopelessness of trying to bring jobs back to America, because even with tariffs, it's still cheaper to produce goods elsewhere. It is not a fiscally responsible thing to build a plant here, and indeed companies are still leaving America. This is a story about Mack Trucks. Mack is really no longer. Mack is now owned by Volvo. This is a video from More Perfect Union. They have a just a host of these types of videos. But what's important is, there's the title. This was published on April 24th, 2025. And Mac is still intending to move its plant to Mexico. There's a URL up at the top. And the bottom line is, building a truck is simple. It's an engine, transmission, heavy frame, some tires, and a cab that's, you know, pretty much universal here in America. We have the long nose, and then you put a name on it. Well, in this case, Mac is made in Lehigh Valley, Pennsylvania, but it's owned by Volvo. So really it's a Volvo. Maybe call it a Malvo, because it's no longer a Mack truck. It's no longer a Mack truck, no more than Freightliner. Runs a Detroit diesel from General Motors. The engine that's in a Mack is no longer a Mack engine. And how the trucks are built is pretty much an automated process that assembles a diesel engine, makes it to a transmission, and drops on a cab. It's not complicated work.
A lot of people, when they think about trucks, they think about a Mack truck.
Park that big Mack truck right in this little garage.
Last year, Mack Truck, the storied American company, announced its opening of a huge new factory. Not here in Pennsylvania, where workers have built Macks for over 100 years, but here in Mexico, where the company can pay workers 1/10 of what its American workers make.
I was dumbfounded.
It was basically like a kick on our teeth, like we're not good enough.
We went to Pennsylvania to speak to the people who build Mack.
No, you're not good enough, because a robot is superior, and it's no longer about American products. The only thing that keeps these trucks being built nearby is the size and cost of shipping a completed unit. Hino comes from overseas. Pretty much all of these vehicles can be made cheaper elsewhere and shipped. The only thing keeping them competitive in America is something like a tariff. You get the point. You can go watch the whole thing yourself. It's just a bunch of people, you know, whining about how Mac screwed them, and that it looks like the, you know, the plant is going to Mexico anyway. There's no tariff on importing trucks. Tariffs on cars. And even if they put a tariff on importing the truck, they could still build it there cheaper and sell it here, even with the tariff, still yet competitively priced. And when it comes down to it, the tariff is simply going to feed the government money, cause a rise in cost of shipping, which is going to float eventually to store shelves, and the American consumer will end up paying it. Now, George Conway and Sarah is up after this. This is a video about how the rich and powerful are outpricing America. Another More Perfect Union video. There's the title. There's the date it was published. It is still relevant today. The people you see in the video are in Montana, and one of them makes the point that where they are, living on the streets in their RVs and what have you not, will soon be under snow. And it was filmed, late summer, before October. It didn't get posted until November. By that time, I'm sure there was snow on the ground. There's a URL up at the top. And
a lot of the people here that live in the campers, urban campers as they call us, a lot of us got jobs. The prices in Bozeman, or Los Angeles as they call it, everything's expensive here.
Welcome to Montana, a state with gorgeous landscapes, sprawling wilderness, and natural resources that have attracted settlers, prospectors, and vacationers for centuries. But what happens to local residents when the government caters exclusively to those outsiders, tourists, and the ultra-rich? It means that some of the wealthiest people in the country are buying multi-million-dollar vacation homes, and private equity is betting on luxury resorts and high-end development.
Yeah, I guess this is as close as we're going to get. So the Yellowstone Club is the only private ski resort in the world.
And meanwhile, just miles away in towns like Bozeman,
you get the point. You need to go watch it yourself. There's a lot of good videos on the More Perfect Union channel. The issue here is very simple. Capitalism is going to kill democracy. The two are not fundamentally compatible, because capitalism is to get the most at the lowest price. That means unions and social welfare programs are not really favored, which is why Trump is cutting everything. You would think before we buy a bill of goods that we would inspect it to see if there's rot. You wouldn't take delivery on fruits and vegetables that are so old they're decaying and rotted. Mr. Trump, as far as is known, has never had a brain scan. Brain scan would show the signs of dementia or frontal temporal dementia, atrophy of the brain. But Trump has always been a little brat, a little idiot from birth. And he's faked it and to make it, and people, because his father, helped him get there. He is the ultimate fake job. Trump himself doesn't have a brain, doesn't have an education in the complexity of what's going on in America. And so what you have is all of his people around him are doing this. They are the ones coming up with this. Make no mistake, this is the Project 2025 playbook from the Heritage Foundation, which is nothing more than a rich man's think tank. The bottom line is they don't want to pay taxes. Taxes are not something that's been around for a long time. Tariffs will work, without a doubt, on the backs of the American people, such to the point that while it may not bring back manufacturing, it will raise revenue from ordinary people who have to spend money on ordinary things that now come from China and Indonesia and other places around the world. They're going to keep coming from there. It's just that the government's going to take a piece of everything imported and charge a tariff on it, a tax on it. By the time it gets to you, you've already paid partial taxes. Then there will be income taxes on you later. And the richest 1% will utilize the loopholes in the tax code to continue paying very little money. The tax rate has gone from 35% under President Kennedy now down to what they're trying to get to 19%. And Trump says he's trying to eliminate it altogether. The difference with Trump is that he's such a grand liar that the lies are built in by design so that the gullible, the weakest of Americans who will believe in what he says and don't know how to look at what he does, well, the question becomes, is Trump really doing it? The chaos that comes out of the White House is more so because Trump isn't coming up with any of this. He's just listening to people around him and making a snap decision, which turns out later to be menacing clowns who have made bad decisions that he bought into and then he has to backtrack out of. So up next is George Conway and Sarah Longwell, where she says they're just a bunch of menacing clowns. Okay, this is Sarah Longwell talking to George Conway about the deportation issues. That's the splash title. There's the video title. There is the date that it was posted. The URL is there at the top. And this is the first thing that the video leads out with. And George is his characteristic long-winded, accurate explanation of everything going on. So I'm only going to play the first few minutes, and there's a URL up at the top. You're welcome to go find this and listen to the whole thing.
They are like the most menacing clowns.
Yeah.
That's it. That's the end of my...
Well, because we have a president who is a...
narcissistic lunatic, sociopath, psychopath.
I was going to stick with menacing clown, but all those are
okay.
true. Menacing clown.
Sure.
He is a menacing clown.
So, don't have time. The video would be too long. Go watch this yourself, and you know, in all deference, she's got her little ads in there that she's got to stick in, so not going to steal that. But that's an apt description, menacing clowns. And this is here because the illustration is that everything that they're doing here, these attorneys all have taken oaths. And they're all performing Section 3 of the 14th Amendment violations. The judge could declare it a 14th Amendment violation and cast it to Congress, which would end up with that person thrown out of the DOJ and then referred to their state bar also. And I think somewhere in here George Conway talks about how state bars may get this information anyway and begin their disciplinary proceedings. But the point is that no one is looking to Congress. Congress is sitting there, I can't say twiddling their thumbs because they really got their fingers up their butt. They don't understand. They are the only thing that can save us from them. They caused this by letting Trump's votes be counted. And you have to believe, because anything else is too painful, you have to believe that they don't understand how Section 3 of the 14th Amendment works. That LAWFARE article was a big Debbie Downer for the entire country because they got it wrong. They got it all wrong. The Supreme Court told you how it works. He is constitutionally ineligible. It's provisionally constitutionally ineligible. They didn't say that. But that's effectively what it is. Because the only three constitutional ineligibilities that are hard and fast in the Constitution are age, residency requirement, and natural born status. The other one, which is the provisional constitutional ineligibility, is the Section 3 of the 14th Amendment violations. And that is what the Trump v. Anderson ruling dealt with. Then they went on to describe that a state can adjudicate that ineligibility for state candidates using the federal Constitution. They cannot do that for federal candidates. State courts cannot adjudicate federal law. Now, a federal court could have done it. However, the federal court that has jurisdiction to do it, the only one that has jurisdiction to do it, is using quo warranto in the D.C. courts by 163501, D.C. Code 163501. Then they define that Section 3 is indeed self-executing. Bottom of page 10, top of page 11. If you take an oath, you engage in insurrection or rebellion. Rebellion is the active verb there, not insurrection. Forget insurrection. People keep on with the insurrection. Don't know how to drop that crap. That's the loser. Then they are barred from office right then and there. But it is not actualized until the amnesty vote is taken by Congress. Congress has to enact the appropriate legislation to cause the amnesty vote to be taken. And if it fails, the amnesty fails, then they're disqualified. People like Jessica Denson can't seem to understand that. Almost nobody understands that. This is the issue. However, the power of Section 3 of the 14th Amendment is there for the minority in Congress to use to throw out the rebellionists, the insurrectionists, and those who will not follow the Constitution, the Christian nationalists, the racists, those who will not promote justice, domestic tranquility, and the form of perfect union, the justices who will not do that. All of that can be flushed by the minority in Congress causing the vote for the 2/3 majority in order for them to keep their job. If they can't make that 2/3 majority to forgive their transgressions, they're gone. That's how you have to view Section 3 of the 14th Amendment. So hit like and subscribe, forward the video on to someone else, and be for sure this is how it works.